Okay, Mr. Chair, we are live.
Thank you all. Welcome to the final 2020 meeting of the New York State Joint Commission on Public Ethics. As we've done in the past several months, this meeting is being held using video conferencing technology. The public session is accessible on JCOP's website to watch via live stream. As a reminder, it's important that only one person speak at a time. In addition, I ask that when you speak, you identify yourself so we have a clear record. As we have done previously, we will take votes by a modified roll call to ensure that everyone is counted. Please remember to mute your phone when you are not planning to speak. Item 2 on the agenda, approval of the minutes from the November meeting public session behind attachment A. Any question or comments?
I'll move them.
Second.
Commissioner Weissman, second.
Okay. Martin, take the roll, please.
All in favor, please raise your hand. I see Rosen, McNamara, Fisher, Horowitz, Weissman, Deering. I'm going to call let's see, Commissioner Cohen. I'll come back. Commissioner DePiero.
Yes.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy. I'll come back. Commissioner Cullen.
Yes.
And Judge McCarthy.
Sorry, I joined late. What's the vote about?
This is the minutes, Judge Yates.
Okay.
Are you in favor?
Yeah, I'm on, and I'm a yes on confirming the minutes.
I will record it. So I have 11 in favor. Motion passes.
Thank you. Item 3, report from staff.
Hi, this is General Counsel Monica Sam. First, I'll start with an outreach update. We issued an ethics reminder recently about holiday gifts. Our fall-winter newsletter is likely going to be published either later this week or early next week. We had to postpone the Ethics Officer Forum on contractors until next year, but we're holding an Ethics Officer Forum on financial disclosure statements on Thursday, January 14th. I'll move on, unless anyone has questions, to an update on the New York City office construction. So for those of you who usually participate there, you know, the New York City office has been fully remote since March. The entire building has been taking advantage of the time and moving ahead with construction, and the lobby has reopened. To expedite the rest of the renovations, we've agreed that the New York City office can be relocated temporarily starting in early 2021 until our new space on the 5th floor is ready, which is expected to be in the fall of 21. So we're waiting for more information about where the temporary space will be. It will either be in the, from the 50 Beaver Street entrance or the 60 Broad. For people in the New York City office, there's 3 entrances, but it's all the same building. It's just each entrance has different elevator banks, so they'll just switch us. The space will not have as many individual offices. It'll have some cubicles, but we will have space to store confidential records, and we'll have access to at least 1 or 2 offices or a conference room for use for confidential purposes. So we'll keep you posted on that. The next issue is the lobbying filing. So as you know, staff, can the people who are not on, could you mute, please? As you know, staff would like to give more time to lobby to submit their statutory filings in light of pending changes to the online lobbying filing system, which are going to be rolling out later this week. We want to give filers until Friday, January 29th, to submit their 21-22 biennial registrations, as well as bi-monthlies and client semi-annuals that are due on January 15th, without facing late fees or enforcement actions for untimely filing. So in other words, we just want to delay any enforcement procedures until after filings come in. We would give them until January 29th. This is consistent with what staff has done in the past when there have been technical problems with the filing system, or what we did in March due to the COVID-19 crisis. We would communicate this to the filers via e-blast and a posting on the website. We'd like to do this as soon as possible. With respect to the changes in the filing system, we are sending a number of instructional documents to guide filers through the changes in the regulations and the filing system. And those are all ready to go as soon as you make this decision. Unless anyone objects, that's what staff's plan is, and we will communicate that as soon as possible.
Mr. Chair,
Yes.
do we need a motion to accept the staff recommendation and move this forward?
You don't technically, sorry, go ahead, Chair.
Go ahead, Monica. I was just going to ask you that question. I don't think we do, right?
A vote is not required. This is something, like I said, staff has had to do from time to time between meetings. Certainly, there's nothing that would prevent the commission from voting, but staff needs this flexibility because often issues arise between meetings where people can't use the filing system, and we have to, give them a day or two of leeway.
No, I absolutely agree with staff's proposal. I'm just asking the question whether or not the commission should adopt the staff proposal.
I don't think we have to, but I don't think it's a problem to do so, George. So if you move it,
I'd be happy to make the motion.
yeah, go ahead.
Done.
Thank you. Second.
I'll second it, Deering.
Thank you. I love you guys. Martin, please.
On the motion to accept staff recommendations regarding lobbying filing deadlines, please raise your hand. All in favor? I see Rosen, McNamara, Horowitz, Deering, Yates, Weissman. Okay, that's the WebEx contingent. Commissioner Cohen? Sorry, go ahead.
Yes.
Commissioner DePiero?
Yes.
Commissioner Jacob?
Yes.
Commissioner Levine?
Yes.
Judge McCarthy?
Yes.
Motion passes.
Thank you. Item 4, attachment B.
That's me.
Go ahead.
Thank you, Mr. Chairman. This is, as you mentioned, this is behind tab B in your books. The proposal before you is to commence a revised rulemaking proceeding for the Commission's, quote, access to publicly available records regulations, which we call our records access regulations at Part 937. This would start a 60-day notice and comment period under the Administrative Procedure Act. This comes out of the deliberations of the Confidentiality and Records Access Committee and has been discussed in concept with the full Commission. With one exception, the proposed changes deal exclusively with information related to financial disclosure statements. Under current law and practice, the only information related to financial disclosure statements that are available to the public are the statements themselves. And so this is governed by Executive Law 9419, which spells out the items that are available, the records of the Commission that are required to be publicly available. The proposal and the regulations would make the following additional information public related to FDICs. 1, date of a filing. 2, the status of a filing, that is whether it came in, whether it's overdue, whether the filer was exempt, whether there was an extension awarded, etc. 3, whether the individual is required to file the FDS and either as a policymaker or as a salary threshold filer. So we would reveal that status. Item 4, for a particular agency, a list of all their filers, a list of titles that have been exempted from filing under our regulations. And then finally, with respect to a request by the filer themselves, they may ask of the commission whether their filing has been requested under these regulations by someone else. Just to note, the proposal spells out clearly that we would not reveal the name of the requester to the filer, only that their filing had or had not been requested. As I mentioned, there's one change that is not related to financial disclosure statements, and that is that the commission would make available the names, titles, and salaries of staff at the commission. As I mentioned, these came out of the Records Access and Confidentiality Committee, and it reflects an attempt to add transparency to our operations where we can within the bounds of the executive and legislative law. I can answer any questions you might have about this one. Mr. Weissman has his hand up.
Thank you very much, Mr. Chair and Martin. Martin, I want to take you to 97B1B. It's on page 2, the top of page 2.
Okay.
Whether deletions have been made to the filing or information exempted.
Yes.
We get, as I understand it, the commission gets the FDS's in 2 formats. They get an electronic and they get it in writing,
Correct.
typed or by hand. Can you go through the process in terms of first deletions, then exemptions, as to how that would be reported? I mean, one's going to be very easy, where it's going to be a strikeout, for example. But how would you deal with it? How are you going to report a deletion in electronic format?
Sure. So the process by which someone requests or and receives an exemption from reporting a specific piece of information, or request to have a piece of information reported to the commission and then subsequently deleted or redacted from public view is governed by Executive Law 94.9. I believe it's HI and I1. But to get to your specific question about how it would play out in a redaction request and a subsequent disclosure to the public, and I might ask Walt McClure to step in if I misspeak, but for redactions, once those have been granted, and those are with respect to the filer themselves, information about their activities, their income, et cetera, that information will have a, as you've seen in many legal documents, a blacked out square over the text with the word redacted in front of it. The law also provides that a filer may request that information related to their spouse may be exempted from reporting at all. And that means that obviously it would not come to the commission. It would simply be, based on the request, excluded from the required information. And I believe, and Walt, step in here if I misspeak, that information would have a similar box that would say exempted.
It would the box would show it would show the black box redacted, and then, or it wouldn't say the word redacted, it would show the redaction. The file name would say the name of the filer, FDS, and it would say redacted at the end of it.
But I think Walt, Commissioner Weissman is alluding to the difference between a redaction and an exemption for a particular question in the filing.
Okay.
So obviously a redaction is very straightforward, but if I'm correct, when a piece of information is exempted, would that be in the field name exempted, or would that?
It would not. It would. I don't. That may be possible. I think it would. In past, it has just shown up as a redaction.
Commissioner Weissman, we can follow up with you and get you a definite answer. I apologize for not having the specifics on that, but I think what you're pointing out is a good point and a distinction that I think we can make in terms of when we disclose it to the public, whether it has been redacted or exempted.
I think the real focus that I'm going at is this was distinguishing between deletion and exemption, but really getting to the exemption question, because there may be instances where exemptions have been granted, and those exemptions are such that they may not or should not be disclosed to the public. For example, if something was under seal
Mm-hmm.
in a court order, uh, it would defeat the purpose. And that's where my focus lies right now. And I apologize for not raising this earlier in the discussion.
Oh, I appreciate you bringing it up now, and as this process is merely the start of a rulemaking, we have opportunities to clarify. I will point out in the regulations that, to your comment about, you know, additional legal proceedings that might be taking place simultaneously, the underlying application for a redaction or an exemption is not in itself public. So we would never reveal the basis for the redaction, only that it had been.
Yeah. I'm concerned about the exemption, especially. I just don't want to. We're doing the right thing in terms of transparency, but there is a balance that we have to not to create an imbalance.
Understood. We can follow up after the meeting and make sure by next meeting that this is clarified for sufficiently.
Thank you very much.
You're welcome. Are there any
Anyone else?
questions?
Mr. Chairman,
Go ahead, Gary.
thank you very much, Mr. Chairman. Before proposing an amendment to the proposal, I would like to get clarified with staff the current practice. And I will interject a personal note, if I may, Mr. Chairman. I've had discussions with staff about inquiries with respect to my own FDS. Specifically, I'm interested in ascertaining if there's been an inquiry either by the Executive Chamber or the Office of Onondaga County District Attorney. Now, do I understand correctly in recapitulating my own discussion? Number one, the current policy is to not divulge whether there was even an inquiry, let alone who made the inquiry. Is that correct?
That's correct. That information is not included in the current draft of the regulations.
And number two, do
Sorry.
I understand correctly that the commission has never voted upon or adopted this practice?
First, let me clarify what I said earlier. When I said current draft, I meant current adopted edition of the regulation. Second, about whether they have ever voted on this, I think, not to parse things too closely, but the commission has voted on these regulations, and the fact that it is not included, you might argue they have voted, in fact, on that exact point.
Well, your point being is that since the current regulation does not specifically provide for disclosure, therefore it has to be assumed that the commission acceded to that proposition?
So if I may, this is Monica Sam. The current regulations adopted the requirements of Executive Law 9419 and provided a process to get the information in 9419. Those are our records access regulations. The information that you were talking about is not required to be made public under 9419, and it was not incorporated into our records access regulations to date. But it is addressed in the current proposal.
Well, again, addressing the current practice, do I understand correctly there is no statutory prohibition to the commission divulging to a filer of an FDS not only that an inquiry was made, but by whom?
I think that's a fair statement that there's no restriction in the law preventing that.
Now, do I also understand correctly, with the caveat FOIL does not apply to us, but that doesn't mean we can't adopt best practice, that under FOIL, an agency FOIL log is subject to FOIL, which is to say that an inquiry could be made with respect to all FOIL requests made to an agency and by whom.
I'm sorry, there was a lot of background noise. Could you repeat that, Gary?
Can I remind everybody, please just mute yourself when you're not speaking? Thank you.
Again, with the caveat that FOIL does not apply to us by statute, but that does not preclude us from addressing and considering best practice. My question is, do I understand correctly that pursuant to FOIL, FOIL requests can be made for the FOIL log of an agency, whereby the individual making the FOIL request would have access to all other FOIL requests that have been made to that agency potentially, and by whom?
So we're not, as you mentioned, we're not subject to FOIL, and so I do not know the ins and outs of the FOIL law. We could certainly get back to you with respect to the answer to your question, but as you do know, with respect to FOIL law, there are various exceptions for turning over information, and one such request may be protecting the identity of someone. So we'd have to do research if you want to answer to how the FOIL law would handle your question.
Thank you. Mr. Chairman, on the proposal.
Go ahead, Commissioner Levine.
Well, the proposal as being propounded leads to a cul-de-sac, a dead end. Unless staff cares to disabuse me of the notion, I cannot fathom what the point is of making an inquiry as to who requested scrutiny of an FDS if the filer is not told by whom the scrutiny was conducted.
Yeah,
Therefore, I believe this regulation should be amended to provide that not only may the filer request whether an inquiry has been made, but by whom, with one exception, which I will propose. The exception being if a law enforcement agency certifies to the commission that the disclosure would interfere with an investigation or identify a confidential source or investigative technique. Otherwise, this information ought to be divulged. There's no reason not to, that I've heard articulated.
So, Commissioner, two things. The first is often a law enforcement request will come in via subpoena, which is not covered by these regulations. The second is obviously you're well within your bounds as a commissioner to make such a proposal. I will point out that the commission, the committee, and staff have looked at this issue previously and come to a not necessarily a legal but a policy conclusion that it would have a market chilling effect on people's ability to request public information if the fact that they made those requests were subsequently going to be turned around identifying who they were. Again, not a legal barrier, but a policy argument nonetheless, and one that has been discussed previously. But I'll shut up.
Well, yes, the usual cogent repose. Let me just say, by way of a sir reply, the way this is being propounded, it's asymmetrical. The filer is put at is given the subordinate position to any individual or entity making the inquiry. In my view, that's not proper. It's not equitable. It doesn't make sense. With the exception of a law enforcement agency certifying that it would interfere with an investigation. So I move the amendment, Mr. Chairman.
Hang on one moment. Commissioner Horowitz, go ahead.
I'd like to ask staff a question or two about this proposal. My first question is whether or not, Martin, you mentioned that there's been a consensus view, or there seems to be a consensus view about the policy reasons in favor of, sort of the amendment as, the regulation as proposed. Are there First Amendment issues here that are implicated by Commissioner Levine's proposal, requests from the Fourth Estate?
I think there's certainly arguments to that respect, Commissioner.
Can you explain what those arguments would be?
Sure. The ability to request public information is one that is granted overall in the FOIA statute, and obviously we are exempt from that. But the law has spelled out certain information that should be available, and that is including the FDS, which is obvious public transparency repercussions. To make the fact that a member of the press, like you said, the Fourth Estate, or merely a member of the public who wants to do their own due diligence, the fact that they have asked to see a public document, to make that fact and their identity available, I think would certainly be an arguable chilling effect. And as you know, there are different standards for First Amendment challenges, but as this is not a time, place, or manner restriction on speech, it would be subject to a slightly less restrictive standard. Nonetheless, I wouldn't want to, walk in unprepared to an argument like that. But as I mentioned, our initial basis and the Commission's discussion focused around the policy, but I think you raised certainly some risk that we could discuss in executive session.
Sure. I mean, the other issue or question I wanted to raise is, so that I want to make sure I fully understand, the public policy behind requiring a financial disclosure for the public officers and public employees in New York State, who are required to fill out a financial disclosure form. Is the underlying presumption with that requirement, for those who meet the thresholds, is the underlying presumption that the filer anticipates that the information in the FDS is public information and will be made known public?
You kind of shifted gears there. I think it's incumbent upon the filer, one, to know that information is public and can be made public. It has been very diligent in its approach over the years to convey that this information is in fact public. And as to whether the intent under the original statute was for the filer to know that, I couldn't speak to that, but I think it's well known and certainly something that we try to emphasize so that no one's caught off guard.
All right, thank you. Thanks, Martin. Thank you, Mr. Chairman.
Thank you.
Yeah, if I may, Mr. Chairman.
Go ahead.
With respect to the First Amendment implication, my view is that if the legislature wanted to prohibit the commission from divulging who is making the inquiries, it would have stated such in the executive law. Moreover, if I'm correct, and I'm not presuming that I am, but if I'm correct about how FOIA works, there's no reason for us not to divulge this information when anybody making a FOIA request is subject to having it known they made the FOIA request.
Martin, can you, just for historical purposes, and it really gets to this press issue, didn't we have an issue several years ago where we proposed a regulation, a lobbying regulation, that the press perceived as some limitation on their ability to get information and to do their job? And this was in the regulatory capacity, in our regulatory capacity, and there was some blowback. And I can't really remember all the details. I think we had a rollback. Can you sort of remind us what that was and explain, are there any overlaps between that kerfuffle and the issues that you've been discussing this morning?
Sure. What you're mentioning is a provision of Advisory Opinion 1601 that the commission issued, I believe, in January of 2016. It's a near and dear piece of work, close to my heart. But what it said was that attempts to influence an act of the legislature or the executive or any governmental action that falls under the lobbying law would include attempts to influence the press, and that is through attempting to get, what's the term, earned media, or using public relations firms to generate editorials. And the theory behind that was that lobbying can take place in different forms, and it can go through different intermediaries, whether that's the public or an attempt to utilize a media outlet. The PR industry, as you can imagine, loved this and subsequently sued us immediately. And before that case could be decided, the legislature in their session that spring amended the Lobbying Act to clarify that speaking to a member of the media could not under any circumstances be considered a lobbying activity, and it was a protected speech. Now, the acts of the media were always protected under the Lobbying Act. What this did was further insulate anything related to the media, even if it wasn't a piece of speech by the media. Sorry. It said that communications with the media, in addition, were not lobbying. And I think to your greater point about these regulations is that the legislature did speak about the need to protect interactions with the press, actions by the press, and that even the slightest restriction on speech, like the lobbying law, which was recently upheld in the Albany Supreme Court and has been held constitutional on numerous times, even that is a restriction on speech, though constitutional. And even that the legislature decided was a bridge too far to cover these media interactions. And so I don't want to put words in your mouth, but I think what you're alluding to is that press activities, when it comes to requesting public information, should be equally protected from this side, if I've conveyed your point.
I was just
Mr.
asking a
Chairman,
question
if I-
and trying to understand, but I appreciate it. And yes, I have serious concerns about anything that's going to chill anybody, whether it's the press or, as you point out, any member of the public, from getting informed about that. And I think we should
Chairman, if
tread
I
very
may.
carefully about that.
Hold on, Commissioner Levine. Commissioner Horowitz.
I finished. Thank you, Mr. Chairman.
Hang on one second, Commissioner Levine. Commissioner Weissman, do you have something you want to add?
Yeah, I have a suggestion. I have a totally different view of the First Amendment here. I think some of the arguments that have been made are specious and probably a red herring that belongs on the top of a Christmas tree or behind a shamus on a menorah. But having said that, I think the best way of resolving this is for us to put this off, have staff take a look at how FOIL actually operates. If Commissioner Levine is incorrect, then we should move these regulations as they exist. If he's correct, then he raises a valid legal argument. And that's what I have to add here.
Thank you. Commissioner Levine?
Yes, I'm very happy to defer to the January meeting. And I also want to say that Commissioner Horowitz and Councilor Levine were persuasive to me that in the hiatus, we ought to consider whether some special carve-out should be for the media. But I agree with Commissioner Weissman, it requires further work.
Martin or Monica, anything you want to add to that?
Judge Yates appears to want to speak. So.
Okay.
Yeah.
Sorry, Commissioner Yates, go ahead.
By the way, does the electric hand signal work, or should I just wave my hand?
Wave your hand, because I can't see Martin, so I can only see a few of you at a time. Martin's
Okay.
mostly tipping me off.
Okay, this is mostly an informational question, if we're going to put it off, and that is, what information exactly do you take down now when someone requests that information? do you verify name, address, email, contact information in any way? And what's to stop people, we do this, from using fronts or shills to make a request when they want to hide their own identity? Especially, a lot of this comes up in the context of a campaign activity where people are looking, one candidate's looking to hurt another candidate. And so, you know, I can foresee a lot of game playing in terms of who makes the request, if it's going to be identified, and then what's a consequence for filling out that form falsely.
I think Monica wants to jump in here, so I don't want to get in her way.
So just with respect to the specifics of your question, candidates and the elected officials they're available on the website, correct? Well,
Candidates are not available on the website. They're available upon request.
So sitting elected officials, their FPSs are posted on our website. So some of this is alleviated in that situation, but with respect to candidates and others, you know, I think the form is not subject to anything other than, you know, a false filing type you know, prosecution, I suppose. But the reality of the situation is they are meant to be publicly available. There's nothing in the form that requires that they attest to who they are. Anyone can get them. That was the design of these forms, is to make them available to the public through a process. So who they are and why they're asking is not part of the policy behind it. So the legislature and the governor at the time when these were passed decided these should be available to the public, to give the public information about the conflicts of their state officers, employees, and elected officials. So it's less about who's asking for it because they're supposed to be widely available.
Yeah, but it's not just
Yes?
it's not just elections. It's for instance, if I'm a reporter doing background research, maybe I don't want, you know, especially if I'm working with sources who want to stay undercover. Maybe I don't make the request in my name. Maybe I have someone else. Anyway, I'm just curious. It's an informational question, not a debating point.
If
Right,
you're
we have
interested,
a
I
log,
could
that log sheet.
say, if you, I mean, I can send you a copy or direct you to where the form is. It basically just requires people to submit their name and contact information so that we're able to supply them with the information. To be honest, I can't think of any situation where anything seemed to be as if someone was hiding that I recall when I've seen these requests.
If we change the law, they will.
Yeah.
All right, anybody else?
You know, it's fine with staff. Again, this is the purpose of these regulations was to implement what the commission wanted to do. This would just delay, you know, making the rest of the information publicly available for longer. You know, the goal here is to put it out there and get public comment so you could hear from the public as well on your proposals while we're doing the research. But if the commission wants to delay, that's fine. It'll just push back when this information becomes publicly available.
Well, may I point out, Mr. Chairman, that all of the balance of the deliberation of the committee has been put over to January. I don't see where it's some great obstacle to public disclosure to have it folded into the entire deliberation.
It's up to the commission.
Does anybody have an issue with us putting this over to January? Okay, so let's move on then. Item 5, new and other business. Commissioner Fisher, I understand that you have something you want to articulate here.
Muted, sir.
Thank you, Chair Rosen. I did have something that I wanted to discuss. So after our last meeting on November 17th, I asked to meet with Martin Levine, and he gave me his time. And what I told Martin is that even though I didn't support Commissioner Yates' resolution of that date, I thought there was a lot of merit in the comments he made about why he brought that forward. And I asked Martin to see if he could draft something that would be successful in finding common ground between the various positions that were discussed last month. And I want to thank him in public for putting that together with assistance from General Counsel Stam, and I was very happy with the result that came out. I thought it addressed the things that I felt needed addressing. But we had a committee meeting of the Confidentiality Committee on Friday morning, and during that meeting, some issues were raised by Jim Yates and others about one aspect of the informal advisory opinions that should be looked at further. The Confidentiality Committee was looking at the difference between our formal advisory opinions, which we may publish, and I don't have the statute in front of me, but I'm sure you're all more familiar with the statute than I am. And that requires us to shield the identifying characteristics of the person who made the request, and there's limitations, but we may publish those formal opinions. But we struggled to find statute or a regulation or anything else that would allow us to publish the informal opinions. And that seemed kind of paradoxical and contrary to what I think the commission is looking to do, which is be more open about the things that we do or our staff does in the case of things that are delegated to them. So what I'm going to ask is, Chair Rosen, if you could refer this resolution back to the Confidentiality Committee, and I'm going to ask that it be adjourned and not voted on today. But I also wanted to thank Commissioner Yates for the time that he spent on the phone with me after the committee meeting on Friday. We spent the better part of an hour on the phone, and as before, the institutional knowledge that Jim has of our commission in general and the legislative history that put these things in place is really valuable to me, and I suspect to other commissioners as well. I just want to thank you, Jim, for the information you imparted to me on Friday, and look forward hopefully to working with you to bring something forward that can win a consensus and a majority vote of this commission. And I'll go on mute.
Okay. And I just want to thank Bill for what I thought was a very thoughtful discussion. We had a lot of good back and forth. And the bottom line is we both agreed that we need to work some of these things through. That was a good result, I think.
Anybody else on this? Okay, so we're going to refer this back to the subcommittee and address it again at some point in the near future. Anything else we need to talk about under item 5, Monica Martin?
Mr. Chairman, may I?
Yes, Commissioner Levine, go ahead.
Have your further indulgence. I would like to revisit the matter of Executive Order 202.6, which exempts from the provisions of the Public Officers Law ethics protocols so-called volunteers assisting the governor in responding to the public health. For the last several meetings, we've had a discussion about making inquiry to the executive chamber about exactly how this executive order is being implemented and who falls within the ambit of it. Before proceeding any further, I want to emphasize for at least the third time, my personal view is the governor should be able to have any resource that he deems valuable and to assist him in responding to the corona crisis. That's not an issue here. My own view is also that he should have assistance from those, even those who have a particular conflict that would otherwise be noted by us. The analog, of course, being the Business Corporation Law, which permits the board of directors of a corporation to waive a conflict if it's in the interest of the corporation. But of course, the underlying premise of the BCL, and it should be the underlying premise here, is full disclosure. So I would like to put a few questions to the staff. Number one, so far as staff is aware, is there any precedent for this executive order, which basically obviates any scrutiny, independent scrutiny of whether there are conflicts and what the import of those conflicts may be?
So I don't know whether there are precedent in the form of prior executive orders by other governors that is similar to this executive order. That is something that we could look into if the commission thinks that's warranted. But as we've discussed, there are principles in this executive order that are not unprecedented. In other words, for the most part, volunteers are not subject to the Public Officers Law. It would depend on the specific job duties that the volunteer is doing. We have precedent that says if a volunteer is doing the exact same job that a state employee is doing, they may be subject to the Public Officers Law, but in most cases, they're not. In addition, contractors, generally speaking, aren't subject to the Public Officers Law. So in that respect, some of the concepts aren't unprecedented. In addition, there is a carve out from the post-employment restrictions for individuals who have left state service but want to contract to provide services in the context of a state of emergency, and that's in Public Officers Law 73-8.
On the follow-up, Mr. Chairman, the executive order, as I understand it, alludes to a recusal policy with respect to those volunteers who are exempted from the ambit of the Public Officers Law. Has there been any public articulation or articulation to our staff as to exactly how that recusal policy functions?
No, as we've discussed at the last few public sessions, I have made the inquiry to the chamber whether or not they have a policy, and the last, as reported back at the last meeting, they said they're thinking about our request, but wanted to know what our basis was in law for making the request, and we did not respond. So I have not had additional communications with them about the executive order. So we don't have the information that you're asking for.
Again, on the follow-on, Mr. Chairman, do I understand correctly, and I put the question to staff, that our enabling statute provides that the commission shall advise and assist all state agencies with respect to conflict matters? It doesn't say we have to be, there has to be a request to us. And there's also a distinction made between assist and advise. It would seem to me that within the ambit of that function, the legislature is about to us, it's legitimate for us to at least ask the questions how this order has been implemented. Am I correct in my assertion with respect to the executive law?
The executive law 94.9J says that the commission shall advise and assist any state agency in establishing rules and regulations relating to possible conflicts between private interests and official duties of present or former statewide elected officials and state officers and employees. I've always understood that we would assist them if they want to develop a policy for their employees, not necessarily one-on-one providing guidance, although we do that frequently under our informal guidance delegation. But if they want to develop agency-wide rules and policies, we assist them.
But that language does make a distinction between advise and assist. It seems to me it's our prerogative to advise the governor with respect to the executive order. Therefore, I strongly urge that a further inquiry be made to the executive chamber. In fact, Mr. Chairman, I'm going to propose a resolution that the staff be directed to communicate in writing to the executive chamber and elicit from the executive chamber the recusal policy. 2, an explanation of whether the order partially exempts current filers. For example, someone's a member of the MTA board, is already filing with us, but then shows up as a volunteer on Corona. Are they then exempted or partially exempted or not exempted at all? Unless staff cares to answer that question. I don't think we know the answer. If in fact the volunteer receives a gift from a lobbyist or another interested source doing business with the state, is the fact of that gift having been offered and received beyond the purview of our commission to investigate? What about a volunteer who's also a lobbyist? Does the executive order mean that the lobbyist is now exempt from our purview in every respect? It seems to me that these are questions that need to be addressed and can be done in a way that does not interfere in any way with the governor's prerogative and legitimate need to enlist people to assist him. Therefore, I move that the staff be directed to make this written communication to the executive chamber regarding Executive Order 202.6.
Mr. Chairman, Marvin, may I make a statement?
Please.
Yeah, I think we're proceeding on an assumption which may not be entirely correct, but tell me if I am right. The assumption is that since we're dealing with an exemption from, for example, Section 74, then there is no basis for us to make inquiries because the legislature has granted an exemption. My understanding of how exemptions work, and I think Dan could help on this point as well, is that an exemption that is granted by a legislature to an agency does not divest the agency of jurisdiction. For example, in the securities laws, there are all sorts of exemptions from registration and other provisions of the securities laws. But the SEC has never regarded that, in my experiences with the SEC, as a divestiture of jurisdiction from looking at the exemption and whether the exemption is applicable. So, for example, municipal securities, state securities or city securities are exempt from registration. But in my experience, they are not exempt from inquiries or from investigation merely because the exemption exists. So here too, I would suggest that the legislature has not passed a law that says that we are divested of jurisdiction to look behind or look into the claimed exemption. It is an exemption, and that's all it is. And when it applies, it applies. But the agency that has jurisdiction under Section 74 has not been divested of its jurisdiction. So that's my analysis of the exemption, and I would welcome staff and others, and especially Dan, who has experience in this area, to comment, if I may.
Chair, this is Monica. Can I speak?
Yeah, go ahead.
So I think to some extent, Commissioner Jacob, I agree with you. Commissioner Yates asked a question on a similar vein at the last meeting. If we had allegations that someone who was either volunteering or working as a contractor engaged in conduct that appears to present a conflict under the Public Officers Law, could we investigate? And I think the commission could make inquiries, and I think the commission could investigate. I think the issue will be, and we would get to this point, we would then seek to find out from the chamber if any, or the appointing authority, the agency that was managing the individual, whether they had opined on how the executive order would affect them. And then the commission would take that into account in whatever it was going to do. So we don't have a specific case in front of us, but should we have a specific case, we would find out whether or not they got guidance about the executive order and whether or not a decision had been made, the executive order applied to them, and then we would consider that. I think there's a difference between some sort of blanket question about how they're interpreting the executive order versus applying it to a very specific set of facts. And it's hard to answer the questions about the application and specific set of facts without that scenario. We wouldn't give guidance to a hypothetical. So I don't know that we're going to be able to hash out various different scenarios at this point. But when we have one, if we have such an allegation, which so far, we don't, if we have that, then we would proceed.
Yeah, Mr. Chairman, just because Marvin invoked my view. I mean, I agree with Monica. Really, to get more to the point, and to quote one of my favorite commissioners, George Weissman, when he said earlier today, what did you say? This is a red herring on top of a Christmas tree or behind a shaman's menorah. It's apples, Marvin, respectfully, it's apples and oranges for the reasons that Monica said. If there's a violation, of course we have jurisdiction. But a few months ago, whenever this issue came up, one of the many times we've had these discussions over the last few months, I think we had a colloquy with the staff about whether or not the legislature would respond in a way that's different than the executive to the current request for information. And I think historically, the legislature has said when we have asked for information that is not required by them to disclose to us, very politely, you're not entitled to that information. And so in the same way that if there is an allegation that a member of the legislature has violated the Public Officers Law, of course we can investigate and use compulsory process to conduct that investigation. But in the absence of a specific allegation, in some ways what's good for the goose, that is the legislature, has to be good for the rest of the governmental agencies that we have jurisdiction over. So I share your view that if there's a violation, of course we should do what we need to do to investigate it. But I'll say what I've said before, which is that to the extent there is not explicit authorization in the statute for us to request information, this is a bit of a fool's errand. And so I stand on what I've said before and agree with Monica. So now, Marvin, you have my view.
Thank you, Dan. Thank you. Although I think on a lot of points we all agree, but Gary has asked that staff make an inquiry and just who has this been applied to as exempt, and that is just an inquiry as to information. You can't really go forward if you have no information at all. So good question, and my experience has been that I've never was prevented from making inquiries because of the existence of an exemption in my practice or in my experience under legislatively granted exemptions. We just made requests, they were granted, and we were never confronted with having to go to a court to get the right, because we weren't divested of jurisdiction because of an exemption.
Did I think Commissioner Yates wants to speak.
Go ahead, Commissioner Yates.
Hi. I just want to put this in context because if I get the drift of Gary's motion, it's we want to try and figure out what the counsel to the governor, for instance, thinks is the scope of the executive order as it affects us. And let me just lay out some basics here, okay? The Constitution says that the legislature may suspend certain laws in case of a disaster. The legislature went ahead and, at the governor's request, amended the executive law in the budget last year. And in order to say that if it's necessary to protect public health, then there could be a 30-day temporary order by the executive to suspend a law. And they said in particular that any suspension should be the minimum suspension necessary to accomplish the goal of protecting public health. So in response to that, the governor first put out an executive order that said that Public Officer Law 74, which deals with self-dealing, bribery, unlawful gifts, unlawful procurements, unlawful disclosure of confidential information, etc., that none of that applied to contractors or people who were volunteers in the pandemic exercise. Apparently, there was second thought about that because, especially for contractors, that would be ridiculous. You can't sit there and say bribery and conflict of interest and self-dealing and giving big companies big awards to your own company or your spouse's company or et cetera, that all of that's okay. So then there was a second executive order that limited it and just said that section 74 does not apply to someone working for a nominal salary or in a volunteer capacity. Once again, with regard to our mandate, and that is there self-dealing? Is there bribery? Are people receiving gifts from interested parties? Are they leaking information to one bidder versus another? Are they awarding a large contract to their own company or their son's company? All of those things that would, if you read just the face of the executive order, maybe not the intent, would be exempted and therefore not a violation of 74 at all. Now, it could be that a conversation with the governor's council would help refine this executive order and let it go into a third tier, which would be a good thing. Because, just because, I don't know, just to pick a name out of the hat, let's say Jared Kushner only works for $1 a year, doesn't mean that he can't have impact on governmental contracts. And it doesn't mean that all the ethics laws should be suspended. I disagree with one of the things, I haven't researched it, but on the surface with casual research, I disagree with one of the assertions that Monica made. And that is that the Public Officers Law doesn't apply to volunteers. That's not the way it works. The Public Officers Law applies to people who function as state officers. And the approach is what functions are you performing, what duties, what obligations do you have? It's not whether or not you sit there and say, well, good, I can award myself $1 million contract and I'll forfeit my salary. It doesn't work that way. So the bottom line is, if someone looks at the face of the governor's executive order, it needs refinement and further discussion because it cannot be that we don't give a darn about self-dealing and conflicts if somebody happens to be working for $1 a year. And that's all I wanted to say.
If I may just respond, I don't think we disagree, Commissioner Yates. What I said is generally the Public Office Law doesn't apply to volunteers, with the exception of when those volunteers are doing a state job, when they are serving in the capacity of a state officer or an employee. But a lot of volunteers are not in that capacity. So we have guidance on this, and that's what I said. So just to be clear, I think we agree. But that being said, it's up to the commission here.
Chair, can I make a couple comments?
Please.
So I think the way I look at this is under the executive law, the governor clearly has the ability to issue executive orders in these circumstances. And I think the flavor, my recollection of some of the flavor of prior discussions related to how the executive chamber was managing um, the executive order, which I think I had indicated before. I respectfully, I don't think it's Jacob's place to get into issues with regard to how the governor's office manages their executive orders. And with regard to the comments today, I think it's the governor's prerogative in terms of what the executive orders say on their face. In terms of if we had any input to assist them if they wanted that with regard to refinement or input or so forth, like that's certainly helpful. But I think in terms of us compelling that we be able to somehow have involvement with regard to what the executive orders say on their face, I don't agree with that if that's anyone's position.
Anybody else?
May I, Mr. Chairman?
Go ahead, Commissioner Levine.
First of all, let me say by way of repose to Commissioner ADJOURN, it is not my intent, my inclination, or my view that the purview of the governor with respect to issuing executive orders should be constrained by us. That's up to the legislature, and the legislature can void his executive order by a joint vote. That's up to the legislature, not us. However, on matters of ethics, our enabling statute says we may advise, which implies opining, on ethics matters within state government. And I don't know how we can have an informed discussion if we don't understand how they are managing this particular executive order. And I further cannot fathom, given all the stress and full disclosure, why the names of the individuals who are within the ambit of this executive order are not being disclosed. And if I may, Mr. Chairman, I'd like to juxtapose this discussion with a discussion earlier in the meeting. Now, I'm a volunteer and have been for decades on the board of the Javits Convention Center in Manhattan. I file at the SDS. Previous discussion was, well, there's a First Amendment interest. We don't want to chill people looking at the financial records and profile and potential conflicts of those who are serving, even volunteers. So we now, in this part of the discussion, are hearing, oh, well, the governor wants to exempt a few people. They don't have to file an FDS at all. To me, it's highly anomalous and inappropriate. Without questioning the prerogative of the governor to issue an executive order, we ought to make an inquiry, politely, respectful. How are you implementing this executive order? If the executive chamber continues to stonewall giving the answer.
Anyone else?
Just one more comment.
Go ahead.
I agree with the comments Monica made before in terms of, if an issue arises, we look into the issue. And my recollection is the the executive order, if I recall correctly, I think there were some provisions in there with regard to the agencies potentially putting certain limitations on volunteers. So I think this, if my recollection is correct, things could change person to person and agency to agency based on the particular facts and circumstances. And I agree with the comments made before with regard to, if an issue arises, we investigate the circumstances and sort it out then. So thanks for listening.
Anyone else?
Commissioner
Commissioner
Weissman has a
Weissman
second.
is trying to speak.
Commissioner Weissman, go ahead.
Just one comment and one question. In terms of the volunteers, and Judge Yates may remember this, going back to when the statute was drafted, there used to be programs such as the Green Thumb. This discussion is bringing this all back to me, where we had volunteers working with DEC to clean up state parks and some of the wilderness areas. Whether or not volunteer has been expanded, one discussion on that. I don't want to engage in that. But my question for council is, do we know whether there are people serving in positions that otherwise they would have to file an FDS that have been deemed to be volunteers and hence haven't filed an FDS? Do we know an answer to that?
Do you mean under the executive order?
Yes. Somebody's brought in as a volunteer and has subsequently been appointed to either FCB, MTA, the economic development agencies. Do we know it?
So I don't, but the issue being if a volunteer is appointed to a position that is a policymaking position, then their appointing authority is supposed to put them into our system to file. They're supposed to be designated to file, whether they're volunteer or they're paid or they're per diem. That's how the system works. I don't know whether there are other types of volunteers who fall under the executive order. We don't know.
Well, so then my
But a
question.
volunteer is a policymaker to be filing. Yeah.
Yeah, so then my question to you is whether or not the rash of appointments that were made in July, whether any of those people, I'm going to skip the names, seem to be volunteered publicly back earlier in the spring, whether they filed. I don't want to get into names.
You went in and out, but there were people who were appointed to positions, governmental positions, and throughout the year who have been added in as filers. So I didn't hear specifically, but if you want to talk about specific individuals, we would do that in the executive session.
Yeah, and it's better
I
done
would
that
have
way.
that information handy.
Okay, thank you.
Anyone else? Okay. Monica Martin, is there anything else before we leave the public session?
Well,
Is
can
there
I have
anything
a
anybody else
motion?
want?
Well, Gary made a motion.
I apologize, Commissioner Levine.
I get required.
I got caught up in all of the conversation around it and forgot about your motion. So please restate your motion.
Yes, thank you, Mr. Chairman. I move that staff be directed to communicate in writing to the council, to the governor, with respect to Executive Order 202.6 and make inquiry with respect to how the order is being implemented. And specifically, what is the recusal policy? Are there partial exemptions for current filers of FDS? Is the ambit of the commission completely obviated to make inquiry with regard to wrongdoing under the Public Offices Law? Strictly an inquiry. Thank you, Mr. Chairman.
Thank you, Commissioner. Is there a second?
Would you accept a friendly amendment? Terry?
Commissioner Levine?
Yes, of course.
First of all, you said, this is just technical. You said 202.6 and it's really 202.6 and 2.7. That's just
Yes,
technical.
thank you.
And the other thing is, me personally, I'm more interested not in the file in Section 73 filing requirements, but in the conflict of interest and the betrayal of confidences, self-dealing, and gifts. So, from my point of view, I would ask staff to inquire in writing of the Governor's Council when 202.6 and 202.7 say that Section 74 of the Public Officers Law does not apply. The quote is, shall not apply to anyone who volunteers. Does that mean, is it their intent to say that all of the conflicts and gift and confidential information provisions in 74 don't apply to someone who's acting as a state officer if they're doing it for low pay in assistance of the pandemic?
I agree to the amendment to the resolution, Mr. Chairman.
Thank you. Is there a second?
I'll second it.
Okay. Martin, please take the roll.
Sure. I'm not going to restate the motion, so I trust everyone caught that with the amendment. So as amended on the motion, all in favor, please raise your hand. I see Commissioners Yates, McNamara, and Weissman. Check those. And have I missed anyone? Okay, and then I'll call the roll for remaining commissioners. Commissioner Deering,
No.
Commissioner Fisher,
No.
Commissioner Horowitz,
Nope.
Commissioner Cohen,
No.
Commissioner DePiero,
No.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
Chair Rosen.
No.
That is 1, 2, 3, 4, 5, 6 in favor. Motion fails.
Okay, thank you. That concludes the public session. I now need a motion to enter into executive session, please.
I'll move, Deering.
Thank you. Second?
Fisher, seconds.
Thank you. Martin?
All in favor to go to executive? Rosen, Yates, Horowitz, Fisher, McNamara, Weissman, Deering. Okay, I'll call the remaining roll. Cohen,
Yes.
Shapiro,
Yes.
Jacob,
Yes.
Levine,
Yes.
McCarthy.
Yes.
Motion carries.
Thank you. We're adjourned. Stand by.
Hold on, please. Okay, we're back in public session.
Okay, thanks. Monica, can you please summarize what we did in executive session?
Sure. We discussed litigation and personnel matters. The commission approved one settlement agreement, and the commission authorized steps in several investigative matters, closed one matter, and discussed several other investigative matters.
Okay, thank you. So unless there's anything else, is there a motion to adjourn?
Shapiro so moved.
I see Commissioner Weissman seconding.
On the motion to adjourn, all in favor, raise your hand. Fisher, Deering, Horowitz, McNamara, Weissman, and Judge Yates. Cohen,
Yes.
DePiero,
Yes.
Jacob,
Yes.
Levine,
Yes.
McCarthy. Motion carries.
Great. Well, happy holidays, everyone.
Happy holidays.
Thank you.
Care.
Happy holidays.